Thank you for visiting my channel. Before we start, please hit the subscribe button so you'll be notified of future presentations. Our topic for today is how to answer bar questions using the IRAC method. The IRAC method is a commonly used framework for legal analysis and writing. It stands for Issue, Rule, Application, and Conclusion. It is a structured approach to legal reasoning that helps lawyers and law students organize their thoughts and arguments. Here is a brief explanation of its component of the IRAC method. Issue. The first step is to identify the legal issue or problem that needs to be addressed. This could be a specific question or dispute that needs to be resolved. Rule. Once the issue has been identified, the next step is to state the relevant legal rule or principle that applies to the situation. This could be a statute, a regulation, a case law precedent, or some other legal authority. Application. The application or analysis stage involves applying the legal rule to the specific facts of the case. This may involve interpreting the rule, applying it to different scenarios, or considering how it has been interpreted by other courts or legal authorities. Conclusion. Finally, the conclusion stage involves summarizing the analysis and answering the legal question or issue that was raised at the beginning. This may involve making a recommendation, drawing a conclusion, or providing a legal opinion. Overall, the IRAC method is a useful tool for organizing legal analysis and argumentation. It helps to ensure that all relevant legal issues and arguments are addressed and that the reasoning is clear and persuasive. The following are examples of an answer or argument that uses the IRAC method. Example number 1. Issue. Was there a breach of contract between John and XYZ Corporation? Rule. In a valid contract, there must be an offer, acceptance, consideration, and mutual assent. If any of these elements is or are missing, the contract is inexistent or void. Application. John and XYZ Corporation entered into a written contract for John to provide consulting services for a period of 1 year for 1 million pesos professional fee. John completed the services as specified in the agreement, but XYZ Corporation failed to pay him the full amount owed. John argues that this constitutes a breach of contract on the part of XYZ Corporation. Conclusion. Based on the facts presented, it appears that John is correct that there was a breach of contract by XYZ Corporation. The written agreement between the parties established the terms and conditions of the contract, including the obligation to pay for the services rendered. Since John completed the services as agreed, but XYZ Corporation failed to comply with its obligation to pay him, the latter is guilty of breach. Therefore, John is entitled to his professional fee plus damages. Here is another example of an answer or argument that uses or applies the IRAC method. Issue. Did the defendant breach the contract by failing to deliver the goods on time? Rule. In contract law, a breach occurs when one party fails to perform a duty that they are obligated to perform under the contract. The duty must be a material term of the contract, and the breach must cause harm to the other party. Application. In the case at bar, the defendant was contractually obligated to deliver the goods by a certain date, but failed to do so. This failure to perform a material term of the contract caused harm to the plaintiff, who was unable to fulfill their own obligations to their clients. Therefore, the defendant breached the contract. Conclusion. Based on the analysis above, the defendant breached the contract by failing to deliver the goods on time. If you find this presentation helpful, please hit the subscribe button to receive notification of future presentations. Thank you.